things that's happened in the Four Corners area with air quality and coal-fired power plants is that there's a void and a need for energy storage. And so we're hoping that maybe we can participate in filling that.
Well, thanks. I think with that we probably should end the panel and thank our 4 terrific panelists. But don't go anywhere because this is we don't have a break between these 2 sessions, and then we'll get you out of here in a timely way.
During the changeover, and all of the panelists and moderator for the next panel are welcome to come over, but thank you to this panel. And I also wanted to take the opportunity to thank my colleagues, Professors Sarah Krakoff and Rick Collins, for moderating so beautifully the past and future panel, and also to invite all of you to join us for appetizers and drinks this evening from 6 to 8 at the Boulderado Hotel, where many of our out-of-town guests are staying. That's on the agenda, but I just wanted to mention it. And with that, I will turn it over to Professor Collins.
Next week, the sequestration's killing us with that, so we're going to figure out a way around, but we're going to get it deployed to you guys here, hopefully within a month. Again, not more. Okay, great. All right, you betcha. Nope.
Oh, sure. Thank you. The presentation was great.
I think it's state and tribal relations. It's not on there. I can get it.
You know me. You know me.
Yeah, that's your 1-5. You want to go to your email?
I can do that. Yeah.
Okay. Second, so go to mine.
Just pull it. Either way.
If it's easy for you to get into yours. Okay. Okay.
Not mine.
Has it been used?
Done. Maybe.
Okay.
Who do we have where?
No, don't copy.
You know, I'm last on the list.
Oh, are you?
You're welcome to
Okay. Well, I was sort of deferring to everybody.
Oh, it's all good.
It is much more important than me. Hi there. Mr. Collins, nice to see you.
You guys are listed in alphabetical order, which is fine with me, but if there's any thought about revising the order, it's okay with me.
Okay.
I'm open to
It doesn't matter to me at all.
Just stick with it.
Sure, what was our sequence?
Just keep inside.
Okay.
I'll be sitting there and I'll just lay them on top of the rail.
Okay.
So you'll just see them laying on the rail. No, there won't be any more disruption than that.
Okay.
Okay. Thank you.
And it's supposed to be 12 to 15 minutes.
Never very good at sticking to
Hey, look at that.
timelines.
It sounds like it's picking us up. So, and what do you do?
I'm going to turn
And you have the CU logo, and it's like, come on, come on. No. That's not mine.
Well, I
Oh,
do
that was
a
yours.
variety of things that requires us to be in contact with states and local governments. A lot of
Across the country.
I don't know. I'd put it in here. I think we should stop. I think we should.
lots of land development.
Thanks. What do you guys Mark?
You set up.
Thank you.
And so those pink and blue.
Yeah.
Blue one means you're close. And
Here,
I'll try and go
I'm
quick.
not going to do anything else.
Okay. You're not going to run up and drag me on.
I'm not sick. It's residual from this one.
we got hit hard this year with that stuff. The young kids and they brought it home this year.
The capital is the traditions.
Yep.
Okay.
Well, let's begin this final session. cheers to all you survivors for sticking it out. And I want to join others to thank Kristen for the enormous amount of work she did in putting this together. Our title for the last panel is State-Tribal Relations, but you can look at the speakers and see that what we have in mind is Colorado tribal relations. We've been remiss in omitting Utah. I'm sure that matters in Utah, but can't fix that now. Back in the 1880s, the U.S. Supreme Court said that the people of the state are the deadliest enemies of the Indian people. Well, we've come a long way since then. Sam Main's talk showed you the immense number of cooperative agreements that the Colorado Ute tribes have with the state of Colorado. And so it's a lot happier now. And that's the basis for today's panelists we're going to talk about today and not 100 years ago. Let's see, we have 4 speakers. I'm going to introduce them all very briefly. Once again, the full bios are in your program, and so that lets me leave out any details. Our first speaker is Ernest House, Jr., Executive Director of the Colorado Commission of Indian Affairs and a member of the Ute Mountain Ute Nation. Let's see, I don't know, who's next? Monty or Patrick? I've forgotten. Monty? Okay. Second is Monty Mills, head of the Southern Ute Legal Department and a 2003 graduate of this institution. Then Patrick Mccoy, who practices Indian law as a partner in Tilden and Mccoy law firm and is president of the Colorado Indian Bar Association, and has a relationship with the Kachan and Cherokee people. Then we have Senator Ellen Roberts of Durango, representing the state in the state legislature, representing Senate District 6. Before that, she served 2 terms in the House. If you know what state legislators are paid in Colorado, you know that that's a dedication to public service by definition. And she's a 1986 graduate of this institution. With that, I'm going to sit down and listen.
Well, good afternoon. Mike Taguvan de Goyak. My name is Ernest House, Jr. I'm the Executive Director for the Colorado Commission of Indian Affairs and the Lieutenant Governor's Office and Governor's Office here for the state of Colorado. It's an honor to be with you this afternoon, and again, I want to also send my thank you to Professor Carpenter and really the institution for taking what we had a discussion about at our quarterly Colorado Commission of Indian Affairs meeting last year in March here upstairs and turning it into what you see today. And I think it's created that fruitful understanding and hopefully more dialogue, and that's what it turns into. I kind of wanted to, before I started, I want to take a chapter from my father's playbook, which is to tell a joke right before I start, and it's usually it's either a hit or miss. But there's these 2 Indians, and they're being chased by the cavalry, and I know a lot of people who've worked with my father probably have heard this numerous times, so I'm sorry to subject it to you again. But basically, there's 2 Indians, and they're running away from the cavalry, and they get onto the horse, and the other Indian tells, hey, let's get on the horse, we'll be back to back, and you can tell me how far the cavalry are, and we'll get away, we'll ride away. He said, okay, they take off. So after a couple minutes, the guy in the front looks in the back and says, hey, how close are they? And he says, they're about this far away. Keep going. A couple minutes later, he says, hey, how far are they? He said, they're about this big. But they're gaining on us. Keep going. A few minutes later, hey, how close are they? He said, hey, they're this big. Hurry, they're gaining, hurry. And he said, why don't you shoot them? And he said, because I've known them since they were this big. I tell that story because I think it has a direct relationship with our state tribal relationships about hopefully they're not shooting first and asking questions later. And that, in my role, I think is a big role and responsibility the Colorado Commission of Indian Affairs has in coordinating with our state leaders, legislative leaders, administrative branch of government, executive branch of government, and then also our judicial branch of government, which I think is a component that's missing. I think we have some champions, like you'll hear from Justice Hobbs tomorrow, but we're making some grounds in. If you were here this morning, you heard Lieutenant Governor Garcia talk about the role of the Colorado Commission of Indian Affairs and how we've strengthened that over the past year. I've had the fortunate honor of working, this is my third administration. I first started with Governor Owens, Lieutenant Governor Norton, transitioned to Governor Ritter, Lieutenant Governor O'Brien, and then now with Governor Hickenlooper and Lieutenant Governor Garcia. And I'm the new kid on the block. I'm entering my 7th year here with the commission, but I grew up attending meetings with Sam Main Sr. and Leonard Birch in DC and learning from a lot of these tribal leaders about and hearing their jokes about tribal consultation policies and what was done in the 60s and 70s, what we're still talking about today. And I bring that to my role here today at the commission because I think that we need to make that shift. We need to shift into a way to change with the times. And I'm not saying that we're removing tribal sovereignty, absolutely not. We need to find ways to strengthen tribal sovereignty. And the Colorado Commission of Indian Affairs has been around for 37 years. And my predecessors have laid the groundwork. And year after year, they've brought forward different ideas and proposals about ways to change the face of Indian country, of Native Americans, of pulling them out of this vanishing culture into something that is real and tangible in today's society. And I think that goes from not only education, but to our natural resources department and across the board. And this morning, there was an individual here by the name of Walter Johns who had the question about our states taking away sovereignty from tribes. And Walter would have a lot of experience because he held this position before. He's held the executive secretary for the Commission of Indian Affairs. And Cynthia Kent, a Southern Ute tribal member who's held it before. And I think over the years, we've seen where the Colorado Commission of Indian Affairs can be effective. Now, a few years ago, obviously the recession has hit a lot of our states, and a lot of our state agencies, commissions that had a direct relationship or impact to Indian affairs in that state were let go, were demolished, or some reason were reformed. In Oklahoma, they took away their longstanding Commission of Indian Affairs and put up a governor-appointed position. I think a lot of our states across the country look to states like New Mexico, and they see a cabinet-level position, and they go, you know what, that's what we need. But not a lot of our states have the population numbers. In Colorado, after the 2010 census, we have over 55,000 American Indians statewide, represented in all 64 counties. But of that 55,000, including the tribal numbers in southwestern Colorado, over 30,000 live in the Denver metro area, including Boulder County, where we are right now. You know, over 77% of the American Indian population lives off of the reservation. And even though we're talking about state tribal partnerships, which we emphasize at CCIA, we also want to make sure that we're reaching out to those families, those parents, those young people who are in our K through 12 school systems off of the reservation too. Going back to CCI's role, we maintain a government-to-government partnership and responsibility. And in doing that, what Professor Collins just said is what we're looking at in the future. You've heard about our Ute history of the past. I'm not going to talk about that. You've already heard that. But one of the new things that we're looking at is when I came back with this administration about 1.5 years ago, I pitched the idea of we're never going to move the needle in Colorado in terms of Indian affairs unless we re-identify our statute. Our statute in the Commission of Indian Affairs hadn't been looked at or even modified in 37 years. And so with the help of folks like commission members like Steve Moore, the Native American Rights Fund, other state agencies were able to look at it and go, how can we implement it to make sure that government-to-government responsibility is strengthened? When other states are looking at deleting, cutting services, cutting programs, how can we prove to Colorado, the governor, lieutenant governor, the commission, the tribes, the Native American community statewide, that we want to be serious with the way we handle Indian affairs issues in Colorado? And we can lean it. We have a lot of successes. I mean, ever since I came, I know Monty's going to talk about the Bruno Agreement, so I don't want to steal his thunder, but I remember when Chairman Frost first brought the issue up at the commission meeting in 2005. It took us 3 years to work on that, 7 years to work with Ute Mountain. But it wasn't just that. It was ongoing discussions about that, and it was about taxation issues and water right issues. It was Dolores Water Project finalized in 1987, or ALP following right after that. The future, what we're looking at now, and what we're looking at issues where we're dealing with, and will we be getting into tribes in terms of across the table discussions, is taxation. Minerals, sales tax, sales use tax, fuel tax, cigarette tax. Those discussions really have never occurred, I think, at the state level. We have this great working relationship, I would say one of the best in Colorado, across the United States, between our state and our 2 Ute tribes. And we've been able to maintain that for quite some time because of these agreements we've been able to put forward. But the next step that we're going to do, and you heard Lieutenant Governor talk about the governor signing this modification, strengthening the Colorado Commission of Indian Affairs just a couple weeks ago. The next step is to really, for myself and to, I think, the Lieutenant Governor of the Commission, is to encourage other state agencies to enter into tribal-state consultations. That's very new to Colorado. Colorado's not a public law 280 state. We're not like other states where, you automatically have a process for consultation. We've created consultation on smaller levels that have turned into be very successful projects like NAGPRA that you're going to hear about tomorrow. And if you're around tomorrow, and I encourage you, because our NAGPRA 7-year project is with an agreement with 47 tribes, not just the tribes here in Colorado. Because there was over 50 different tribes that once called Colorado home. And as a member of the Ute Mountain Ute tribe, I hold that in high regard in terms of our relationship with our Utes. But I also want to make sure that we identify those other agreements or those other relationships that we have with tribes that are located outside of our state. Those state tribal consultations, 3 state agencies signed those agreements a year ago. The Colorado Department of Public Health and Environment, the Colorado Healthcare Policy and Financing, which operate Medicaid, CHIP Plus, Medicare, and the Department of Human Services that looks at social services, welfare, ICWA, food distribution. I'm happy to say that in February we hosted our first state tribal roundtable with the Department of Human Services. We brought down state folks to meet with tribal representatives at Ignacio with both Ute Mountain and Southern Ute. And we're going to get into this process of doing this annually so that the state knows that there's this obligation to come down to Indian country, the Four Corners, and to meet about ICWA issues, about food distribution, you name it, and the list goes on. But we're going to move that into the summer and fall with the Colorado Department of Public Health and Healthcare Policy and Financing. Especially now with, and I just came along with folks here in the audience yesterday at the Region 8 U.S. Department of Health and Human Services Federal Tribal Consultation meeting. State tribal relationships was emphasized even at that level. I think that for so long, tribes, rightfully so, because of the fiduciary responsibility of treaties for healthcare, education, and public safety, we know that there needs to be a tribal consultation policy at the federal level. Looking at a state tribal consultation policy is new, and I think for some state agencies it frightens them. For non-Indian communities, it says, well, wait a minute, I didn't think that was our obligation. How is that our obligation? We don't hold jurisdiction. We don't hold the dollars. Well, actually, in some cases, we do. A lot of our state agencies don't know that there's federal pass-through dollars. A lot of them don't know that through Juvenile Justice Delinquency Prevention Council that some of our folks sit on, that there are dollars held to go to tribal communities. We've never really compiled a dollar amount saying, Ute Mountain, Southern Ute, other tribes, this is how much we have available. Because if we come to that point, which is our hope and what our goal is going to be, we can carve out X number of dollars and say, look, this will always be available to the tribes no matter what. This is a non-competitive process. We understand that the tribes are drinking out of a fire hydrant on their end in terms of federal obligation, regulation, compacts, you name it. I don't want to add more confusion to the mix, but I also want to hold our states accountable where they need to be held accountable. And I think that there's no way we're going to be able to move that needle unless we create and develop these state tribal consultation agreements. And the other unique thing about these consultations, as you see with no matter who's in the administration, the presidency, they always continue. And it looks like they're strengthening over time. When you first started and you first heard about them in the 60s or 70s and where they are right now, it's a great process. And that's what I think the state of Colorado is looking and entering into. The other thing that Colorado is looking at developing is a state uniform contract language. We've looked at policies with Department of Transportation to other state agencies where we've always had to create these new agreements, and I've called Monty numerous times, and I've called Peter Ortego numerous times, and we've said, look, can we create this new MOU, MOA, IGA? And it all comes down to, wait a minute, we're not going to waive our sovereignty, you're not going to waive our sovereignty, there always is a roadblock. So we're hoping that we can create a uniform contract language that will be broad-based across all state agencies, that no matter what state agency is doing business with the tribes, it'll be a pre-approved agreement, so that it'll continue to not only award contracts or look at ways of intergovernmental agreements, but we don't have to spend so much time and effort and all this process on the tribal level and on the state level into trying to understand the language of the two. And last but not least, I just want to also end with our work with NAGPRA. Like I said, you'll hear more about it tomorrow, and there's folks in the room who've really led the charge. Mr. Terry Knight, who you'll hear from tomorrow, I believe he's here, but he also was the one who asked the question on why we don't have more of these. And that, in my mind, is really the purpose of why we have groups like this come together, so that we can understand the collaborative process of trying to partner more and more. Think outside the box. I would go to some of these tribal consultation meetings and you hear the same thing, and I hope we're not too many talking heads up here, but I also want to try to change it up a little bit, to the bit that it can be changed. That we make sure that we hold not only our state accountable so that we know that history does not repeat itself, but that we're fortunate right now to have a great relationship, but we know that not all states, and Colorado may not always have a great relationship between the tribes and the state. And I want to make sure when that time comes, we make sure that there's already a foundation laid out so that we have a great understanding that we can get over those hurdles when and if they do come. And I think that is what the challenge is going to be to the next generation, is how you change that, how you are going to be a voice for your own Indian community. Not just Ute Mountain or Southern Ute, but as Native people in general. And I think that we've had the fortunate opportunity of hearing from these great leaders, and leaders that I know would have been here, like David Lester and others who led the charge for so many years, and saying, okay, now it's time for folks to see where we can take this game. So with that, I'm anxious to hear from these folks here. It's an honor to be with you again, and the Goya, thank you for the opportunity.
Good afternoon, I'm Monty Mills. I'm Director of the Legal Department at Southern Ute. Appreciate those of you who have stayed. If law students today are anything like they were when I was in law school, there are a few things that can stand between them and happy hour. So I'm glad that those of you who have stayed are sticking it out. I do want to, just following on what Ernest had to say, I think he's being modest about those who laid the groundwork. Ernest really is central in the relationships and the good relationships that the Colorado tribes have with the state. For some of us, he is our personal consultation policy, and he really does play an important role in that relationship. So I'd like to say it is an honor to be here. I owe a lot to University of Colorado School of Law. Don't worry, it'll be paid off in 2023. But I do owe a lot. It got me to where I am, bestowed a lot of honors on me. Not the least of which was meeting my wife here in the first year of law school. So what I'd like to talk about today are state tribal relationships, between the Southern Ute Indian Tribe and the state of Colorado, generally to begin with. But then what I'd like to focus on is one example of how the state-tribal relationship can really work, and that is the 2008 MOU, pursuant to which the Southern Ute Indian Tribe began to re-exercise its Bruno Treaty rights. And there have been a lot of discussion today about the history of the reservation, the Bruno Agreement, even this MOU was mentioned. But what I'd like to do is get into a little bit more detail about that process, because I think it really is a good example of how a strong relationship between a state and a tribe can really produce benefits for both the state and the tribe and avoid serious political and other issues that tend to derail those relationships. So first, generally, the tribe and the state of Colorado have a great relationship. Mr. Maines mentioned earlier that there are a number of state-tribal agreements on a wide variety of topics. Those include agreements about the revocation of driver's licenses on the reservation, the implementation of the Indian Child Welfare Act, the taxation compact that Sam mentioned earlier. Important agreements about important topics that affect the everyday life of Indians, tribal members, and other Indians living on the reservation. In addition to those sort of broader agreements, the tribes also engage with local governments on a day-to-day basis, and through the course of those engagements has agreements on more specific things. Because, as was mentioned earlier, the history of the Southern Ute Reservation has led to allotments and homesteading, and that means that there are non-Indians living within the reservation boundaries. The tribe and the county have to work together in order to ensure that the citizens of the community are well served. So even things as simple as doing a corridor access study to determine how a highway should be planned require agreement between the state and the county and the tribe. And in fact, one of the first ever such agreements was entered last year. It's called the Ignacio Area Corridor Access Plan, or the ICAP, by and between the tribe, the town of Ignacio, the state of Colorado Department of Transportation. So something even as simple as determining how a road is going to go through the town of Ignacio requires intergovernmental cooperation and that the governments work together. So state-tribal relations are not just something that exists in a vacuum and are conceptually nice, but they are in many ways a requirement of day-to-day operations of the tribe. So to begin with, I just would like to point out that you'll note that the seal of the Southern Ute Indian Tribe does incorporate the state of Colorado's flag, even though the tribe long predated the establishment of the state. Note that the seal isn't incorporated into the state flag, however. Just begin. So we've covered a lot of the history of the reservation. Everybody knows the state of Colorado. The original reservation of 1868 is guaranteed by the treaty that Professor Wilkinson and others spoke about earlier today. Subsequent to that, and as was mentioned earlier, Felix Bruno, which is the reason the Bruno Agreement is called the Bruno Agreement, or as some say, the Brunot Agreement, was the Indian commissioner that traveled to the Los Pinos Agency and negotiated the terms of that agreement. And this is language from the actual agreement, that the Confederated Band of the Ute Nation hereby relinquishes to the United States all right, title, claim, and interest to the described portion. And that portion, as has been demonstrated on maps before, was basically the San Juan Mountains, that chunk that's been eaten out there of the original 1868 reservation. But as, well, and just for reference, here are the current, the present-day reservations from 1878 on. And I would point out to Professor Collins, this map actually includes the accurate boundary straight across. But as one of my professors here, Professor Hines, said, you should always follow Blythe's rule, which was to read on farther in the agreement. So not just in the cession of the Bruno area, the Bruno Agreement also included in Article 2 that the United States shall permit the Ute Indians to hunt upon said land so long as the game lasts and the Indians are at peace with the white people. Now you will note that the language says shall permit, but I think as Professor Wilkinson noted earlier today, this reservation of these rights by the tribes was an important aspect of the agreement, something that was critically important to the tribes at the time. So not just that the United States permitted this, but that it was reserved expressly and explicitly by the tribes in the course of the Bruno Agreement. So why would those rights that were reserved by the tribes be important? Well, subsequent case law about some of these things have determined that the canons of construction for treaties, when applied to this agreement and other treaties, require that those terms be interpreted liberally and in favor of the tribes, and that the tribes would have understood them at the time that they were negotiated. So use of the term hunt, for example, in the Bruno Agreement doesn't just mean hunt. It would mean whatever that term meant at the time the agreement was negotiated, and that could include fishing and gathering and additional activities that were implicated by the word hunt. So it's not just that the agreement reserved the rights of the tribes to be on those lands for these activities. It carries on beyond 1874 important rights that the tribes reserved through that specific language. I think Sam had this slide in his presentation. This gives you some idea of the relationship between the existing Southern Ute Reservation here and then the Bruno area. You can see that by virtue of the landmass, the Bruno area is enormous. It's about 5.5 times the current reservation, or approximately 3.7 million acres. Here's another more detailed picture of the landmass that's encompassed within the Bruno area. You can see generally it stretches from Pagosa to Cortez, from Ridgeway down to the northern line, or approximately Bayfield. The green lands there are Forest Service lands, and the yellow are BLM. You can see it incorporates a significant amount of federal land. It's basically the San Juan Mountains, but you can imagine that contained within the Bruno area are some of the state's most beautiful areas, as well as some of the most plentiful game resources. This gives you some idea of the details of the Bruno area. It includes those major reservoirs, significant gold medal and other fisheries, ranges from approximately 6,000 feet in elevation down by Cortez, all the way up to Uncompahgre Peak near Lake City, which is over 14,000 feet. I included some pictures as well, just because it's beautiful. I think that's Telluride there, which is incorporated into the Bruno area. Nice fall foliage as well. So, from the time of the Bruno area until approximately 1972, these rights were in force, and tribal members were able to hunt and fish, exercising those rights. In 1972, however, 2 tribal members, believing they were exercising their treaty-reserved rights, actually harvested 3 mule deer within a state highway right-of-way. And the state cited them for illegal taking, and they were prosecuted in accordance with state law. The tribe took exception to that prosecution, as you might imagine, and joined those tribal members in a federal lawsuit challenging the state's authority to exercise, to basically prosecute those tribal members by virtue of the harvesting of those deer. The result of that federal lawsuit was a stipulation and a settlement that resulted in an agreement to dismiss those cases, dismiss the prosecution, and an agreement by the state not to assert or challenge the tribe's authority to regulate on reservation hunting and fishing, an agreement by the tribe to refrain from exercising those off-reservation rights. So the tribe, by its own free will in this agreement, agreed to refrain from using those rights in order to avoid further conflict with the state. Importantly, however, the stipulation and settlement expressly reserved the tribe's Bruno rights. So those, by the terms of that agreement, although the tribe voluntarily refrained from exercising them, those rights were still preserved in the language of that stipulation and settlement. So from 1972 up until recently, that was the status of the tribe's off-reservation hunting and fishing rights. They were preserved by the terms of the stipulation and settlement, but the tribe was not exercising them. Following that then, in 2006 and as early as 2005, I think through the CCIA meetings, the Southern Ute Indian Tribal Council and specifically Chairman Clement Frost and others decided, you know what, we'd like to go back and revisit this issue, this stipulation and settlement in 1972, and we want our tribal members to be able to exercise these rights again. And so that began discussion by and among tribal representatives, tribal leaders, and state representatives and state leaders about how best to go about re-exercise of these rights. And in November 2006, Tribal representatives met with the Colorado Wildlife Commission in Colorado Springs to begin discussion of a memorandum of understanding that would outline how the tribe would exercise these rights. Now, there are some important things about the approach that the tribe took that I think makes this agreement somewhat unique. Now, these are aspects, I think, generally of the tribe's approach to relationships with the state, but they played a central role in the Bruno Agreement. First of all, there's a strong relationship between local staff. So tribal staff, Department of Wildlife staff, State Division of Wildlife staff work together on a day-to-day basis. They know each other, they trust each other, and I think that really helped support the discussions that took place even at higher levels, because at a staff level, folks could get along. Secondly, the tribe has a successful history of wildlife management on reservation that began as early as the 60s. The tribe adopted a wildlife code as early as 1981, and currently, and for the past 10 or 15 years, they've employed highly trained and skilled professionals to manage on-reservation wildlife resources. For example, each year, the tribe hires a helicopter company to come up and fly wildlife professionals around the reservation to do game counts so they can manage those populations in a science-based manner and ensure that the tribal members' ability to exercise on-reservation rights are sustainable for the long haul. Third, as I mentioned earlier, there have been a number of agreements between the tribe and the state that predated this one. And this really built upon that goodwill and the trust that the state and the tribe had already established through those prior agreements. And lastly, and maybe most importantly, I think the tribe and tribal council, the tribal leadership, really recognized that tribal members hunting off reservation, potentially in seasons that didn't line up with the state hunting seasons, posed the potential for significant political issues. I think the council really recognized that this was a sensitive topic, that non-Indians in the state cared deeply about their ability to hunt and fish, and that if the approach was done wrong, there could be significant backlash that could impact the tribe's ability to successfully exercise those rights down the road. So from the beginning, the tribal council took a realistic approach to how to go about doing this. And by example, although they may have been able to do it, I don't think anyone on the tribal side ever envisioned encouraging tribal members to go bag elk in downtown Telluride. So the tribe really took a realistic approach to what they could and couldn't achieve through this process. And I think that really helped, particularly when communicating with the state about what this might look like. So throughout 2007, 2008, the negotiation of this memorandum of understanding took place, building on those four things, really. And when I think state officials understood that what the tribe was really planning to do was simply manage their own rights in the same way that they manage on-reservation rights, the tribe had an existing program that had worked well. It really made the negotiation of those terms quite easy. We reached out, importantly, also to local government officials. You could see through that map, there are a number of counties, states, or counties, cities, and towns within the Bruno area. Tribal representatives, along with their state counterparts, met with local county commissioners and explained what was going on so that those county commissioners would be aware, wouldn't be blindsided by, their constituents coming up to them and saying, hey, what's the tribe trying to do, with this off-reservation hunting thing. Really explained what the tribe's approach was so that everybody was on the same page when it came to what was going on. It really was a cooperative approach to try and respond to questions and concerns that came up. So in September 2008, the agreement was finalized. It was titled the Memorandum of Understanding. There's a picture of it. I will note, however, the tribe did not expect that it would be put on state of Colorado letterhead. That happened at the governor's office. But, we'll take it. The agreement is still what it is. So just by brief overview, the terms of the MOU really establish the manner in which the tribe would exercise its off-reservation rights. And it sets up a framework for how the tribe and the state would work together. It doesn't, for example, say, these are the seasons, these are the dates, these are the specifics of how the tribe will do it. Rather, it establishes a cooperative framework for the two sides to work together to communicate about those details going forward. So it really was intended to promote cooperation and communication in the management and use, to avoid confrontation between the two parties in the exercise of enforcement jurisdiction, to provide a process to resolve conflicts between the tribe and the state, and also to facilitate the exercise of the tribe's rights in a manner that's respectful of the interests of the other parties in the Bruno area, including Ute Mountain and the state. In addition, the specific terms talk about the principles pursuant to which the parties would manage the wildlife resource, be done in a collaborative manner through communication and cooperation, and really based on the best available science. I think, as I said, once the state understood, whether it was from the tribal wildlife folks or even their own division of wildlife folks who were in the local area, that management had worked on reservation, they had a much better understanding for what the tribe's management would look like in the Bruno area. The parties agreed to share their regulation and discuss issues of mutual concern, including areas that would be closed, harvest levels, those types of things. Similar to the water rights agreement, I think that someone mentioned earlier, the tribe can authorize ceremonial hunts within the Bruno area. And when it comes to rare game, which is really a topic on which it seemed the most sensitive, the parties were able to reach agreement that each year the annual allowable harvest would be set and a certain percentage would be allowed for tribal hunters to harvest those rare game species, which include bighorn sheep, moose, those types of things. With regard to law enforcement, each party would exercise their appropriate jurisdiction, the tribe over tribal members, the state over others, in accordance with those parties' laws, rules, and regulations. And then there was also a process for technical assistance, training, etc. There was a dispute resolution process that preserves both the respective jurisdiction and the sovereign immunity of the parties. Again, it was important, I think, to both sides, kind of like was done in the stipulation and settlement agreement, to note that regardless of what the terms of this agreement were, it didn't modify the fact that those treaty rights still exist and still will persevere, notwithstanding any dispute that may occur in the context of this agreement. The MOU then concludes with a series of miscellaneous provisions. Now, while negotiation of the MOU was important, from the tribe's perspective, it was also equally important to ensure that following that, before tribal hunters got out in the Bruno area, local citizens, local governments, everybody understood what would be going on. So again, we avoided conflict about the rights that the tribe would be exercising. And as had been consistent throughout the negotiation process, the tribe and the state agreed to work together through education and outreach to local organizations. And so they held public meetings, Durango, Montrose, Denver, jointly with both representatives from State Division of Wildlife and the tribe's Wildlife Division to talk about what the MOU said, what the MOU did, and the rights that the tribes would be exercising. That really paid dividends in the long run. And here's actually a sheet of frequently asked questions that was distributed at some of those meetings. It really paid dividends in the long run, and perhaps the best way that was illustrated was about the time that these meetings took place, there was an article in the Denver Post, and there were a number of guides and outfitters who were commenting about their uncertainty about what the tribal hunters in the Bruno area would cause, what problems they would cause for non-Indian hunters. At the conclusion of that article, however, there was an outfitter, and I can't remember if he was from Pagosa or somewhere, who said, you know, I really don't agree with the tribes and tribal members being able to go out and exercise these rights, but you know what? There were rights that were guaranteed a long time ago in the 1800s, and it would be the right thing to do to stand up and honor those rights. And to folks who had worked on the agreement, I think that really demonstrated the power of this outreach and education effort, that even though a non-Indian guide and outfitter believed that the exercise of these off-reservation rights may impact his business, he was still understood enough about the power of treaty rights to respect the fact that tribal members had these rights, and it was the right thing to do to live up to those rights and honor them. So since the time of the MOU, now what the tribe does each year since 2009 is develop annual regulations for hunting and fishing in the Bruno area. Those regulations are published in the tribal newspaper. There's an example of them. And include rules for the harvest of animals in the Bruno area. The tribe issues permits to tribal members to go out and do it. And so since the MOU was negotiated, it's resulted in the re-exercise and the rekindling of those Bruno Agreement rights that were guaranteed in 1874. So the negotiation of this MOU, the enactment of the MOU is really an example of strong state and tribal cooperation and coordination. So just to close, while this is a good example, it's certainly not the only example of the strong relationship between Southern Ute Indian Tribe, Ute Mountain Ute Indian Tribe, and the state of Colorado. I think it's remarkable when you think about the relationship and the comments made by Governor Pitkin just over 150 years ago, and the fact that just over a month ago, Chairman Newton, other members of the Tribal Council were able to sit down with Governor Hickenlooper, Lieutenant Governor Garcia in the Lieutenant Governor's office and have an open and frank discussion about the issues that are facing each respective sovereign government and do so on a government-to-government basis. It's pretty remarkable to think about the development of state-tribal relationships and how far we've come. And as Executive Director House noted earlier, what the future might bring, I think, will continue to build on this positive foundation, and we look forward to continuing to work with our state counterparts. So thank you again.
I'm Patrick McCoy. I wanted to thank Professor Carpenter for inviting me here to talk about an issue that affects tribal-state relations and certainly has the potential to fracture tribal-state relations if it's not handled correctly, especially today, even more than just a few years ago. No jokes to start with, but an anecdote. I was trying to tie my tie this morning, and about the third time I got a little frustrated. My 9-year-old son was standing next to me, and he said, "Hey, Dad, on Easter I wore a tie." I said, "Yeah." He said, "Well, you guys went out and bought me a tie that's pre-tied and it's got a zip on it." And I said, "Yeah." He said, "You should try the zip tie." And it's relevant to this discussion, actually, because I'm thinking, if we can do things as tribal leaders, tribal members, and advocates and attorneys in an easier way with tribal and state governments, especially counties with respect to land and trust, we should do that if there's an easier way available. So use the zip tie. I am from the Fort Yuma Reservation, the Quechan tribe. If you think the Rocky Mountains are beautiful, come to Winter Haven, California in August, and I'll show you a good time. It is very beautiful. It's called Winter Haven because the best time to be there, of course, is in the winter when it's 70 degrees and you can play golf all winter long, which is great. I wanted to talk today about mainly the Patchik decision, which came out last year. It's a Supreme Court decision, but I'll give a little bit of, there's a lot more here than I can cover in a few minutes. So I will speed quickly through here. I'm a partner at a local firm, Tilden, McCoy & Gilweg, where we practice Indian law. I see some of our associates in the audience, Rebecca and Brandy and Carrie. Thank you for being here and for sticking it out. Many of us in the room probably know about land and trust and why it's so important. Just very, very briefly on the history, and we've seen many, many maps today about the Aboriginal territory of the Ute tribes, Colorado and New Mexico and Utah. But of course, the issue is the same for many, many tribes across the United States where the Aboriginal land base was decimated.
I'll put this on the show.
Oh.
The slideshow.
Certainly. So the Aboriginal Indian or tribal land base was heavily decimated, especially here in Colorado, and most of the tribes that are Aboriginal to Colorado were removed, of course. And so starting with European contact and westward expansion and removal policies, and of course the Allotment Act, where that removal was in a sense codified by Congress into the General Allotment Act, which caused, is Professor Wilkinson talked about this morning, the loss of several million acres from 140 million acres down to 50 million acres after allotment happened. And so land in trust, and the process for putting land back into trust is an effort to rebuild the land base, the Indian land base, as Chairwoman Kutch this morning talked about, how to rebuild the Ute Indian land base, but also the tribal land base across the country. So there are many ways that land can go back into trust. Of course, Congress can do that and has done that several times, usually in tribe-specific legislation and restoration acts. Courts, federal courts, under their equitable powers, can also order that certain lands be placed back into trust. Probably the most popular way to at least try to put land back into trust is through the IRA, or Section 5 of the IRA, a 1934 act passed by Congress in response to the allotment policy, which had decimated the Indian land base. So one of the provisions of the IRA provided the Secretary of the Interior the authority to acquire land in trust for Indian tribes as a way to make up or rebuild the Indian land base, because Congress understood, or began to understand, that tribes are land-based cultures. We need land, we need waters to survive. That's how we've always survived. So in 1980, the Interior Department enacted regulations to implement Section 5 of the IRA, and so we call those regulations 151 or 25 CFR 151. That's the main way that tribes and Indians attempt to have land taken back into trust. But it's not easy. Those regulations are not terribly detailed. They're somewhat misunderstood, both by tribes and by others. Certainly adjoining counties and states don't understand the process all that well. This is way too much to get into, but what I wanted to talk about today was the Patchak decision that came out last year, the Supreme Court decision. Probably it's more helpful to switch to the next slide, but just briefly, the Gun Lake Band, the Nashuish Band of Potawatomi Indians in Michigan requested land in trust for a gaming establishment under IGRA in a rural farming community. So, and they encountered problems, to no surprise, that they were going to do that. Skip past some of the finer details of the case. That's the general setup, as tribe asked the Bureau of Indian Affairs to put land into trust in Wayland Township, Michigan, a small rural farming community where the tribe wants to build an Indian casino. And of course, there's going to be lots of controversy surrounding that area, or surrounding that topic. The department has the application for some time. And by the way, I was not involved in the case at all, so I don't have any inside information to share. I'm just an outside observer to the case. Had the application for some time. In 2005, the department grants the application, says, yes, we'll take the land into trust. But under the regulations, once the decision is made, there's a mandatory 30-day wait period that the department has built into its 151 regulations. So decision and then 30 days. And the purpose of the 30 days was to allow counties, landowners, interested parties to come forward and file lawsuits to stop the actual conveyance of title into trust before it happened. The reason for that I'll get into in a second, but inside that 30-day window then, an anti-gaming organization, MISCO, in Michigan files a lawsuit. So when the lawsuit is filed, the department stays its acquisition of the land into trust, or it's under its quote-unquote self-stay policy. MISCO's claims are denied. Then Patchak, this litigant, files a suit against the United States, claiming that building a casino in this small rural farming community is going to destroy basically the aesthetic of that community. And his claim was based on the statute, on IRA Section 5, the Land into Trust statute that Congress passed in 1934, which, by the way, is very, very vague, says very, very little about the process. He did not, however, claim that the property requested to be put into trust, which is called the Bradley property, he didn't claim that that was his property. He simply sought to have the land taken out of trust. The reason I put an event sequence up here is because the sequence of events is a little confusing. So 5 months after Patchak files suit, the Supreme Court denies cert on the first piece of litigation. So finally resolving that piece of litigation. Then the department takes the land into trust, actually acquires title. I'm not sure why they did that if they had a self-stay policy in place. It's a little confusing, but so 1 month after the Bureau acquires title, Supreme Court decides Carcieri, which becomes a very big case very quickly, and says, Secretary, that authority we gave you in 1934 to take land into trust for tribes, that only applies to tribes who were, quote unquote, under federal jurisdiction in 1934. So throws land into trust into a bigger controversy and imposes on the case that additional issue of whether Gun Lake was, in fact, under federal jurisdiction in 1934. Not surprisingly, to those of us who practice in the field, U.S. District Court dismisses Patchak's suit. It says, I'm sorry, Patchak, you're a nearby landowner. You were not considered by Congress in 1934 when it enacted the statute. Your interests, the interests you're claiming will be harmed, are not the kinds of interests that Congress was concerned about. It was concerned about putting land back into trust for tribes. So no surprise that the district court dismissed the claim. So it was a surprise then when the D.C. Circuit reversed. And it held two things, only one of which I'll talk about. One, you do have standing, Patchak, even though you're just a landowner. We look at 151 as really a land use kind of regulation. And since you're a nearby landowner, and since you're claiming the use of the land that the tribe wants to put the land to, the casino, is going to interfere with your use of your own property, we think you have standing. And then the second issue, which is the Quiet Title Act. So Patchak was suing the United States to take the land out of trust. You can't sue the United States without a waiver of sovereign immunity. The Quiet Title Act generally provides that, except where you seek to take land out, Indian lands out of trust. It's an exception to the Quiet Title Act. So that's the reason that the department has the 30-day wait period in the regulations. They want you to file suit, or pre-Patchak, they wanted you to file suit before that 30 days dropped, because once that 30 days expired and they actually acquired the title into trust, you had no jurisdiction. There was no waiver of the United States sovereign immunity to get into court. Well, the D.C. Circuit says no, that's the Quiet Title Act. That only applies to litigants who are actually claiming that that land is theirs, where they're claiming an interest in that land. Patchak, the court said, and then the Supreme Court affirmed, said Patchak, the plaintiff, didn't claim an interest in that parcel. So it wasn't technically a quiet title action. So the exception doesn't apply. The Quiet Title Act waiver is available. Patchak can sue. So this changed everything, because we, in the Indian law world, and certainly the department, thought that once Indian lands went into trust, that was it. They couldn't be taken out of trust. There was no way to get there. You can't sue the tribe unless they waive, and they're not going to waive. And you can't sue the United States because there's no waiver under the Quiet Title Act. So this changed everything. the department had put this self-stay policy into place years ago because they wanted litigants to have an opportunity to bring their claims. The United States, isn't in the business of precluding judicial review. Generally speaking, the government is in favor of judicial review, so that's what they were trying to provide by that 30-day window. And 151 itself doesn't say anything about any stay during the pendency of litigation. So the department instituted the self-stay years ago until recently. So after Patch Act, folks at the department said, well, what do we need the self-stay for anymore? If you can sue to bring lands out of trust, then let's just take land into trust as soon as we make the decision. What's the point of the self-stay? It doesn't make any sense any longer. And so they signaled to the public that that's what they were doing. Well, very quickly, many folks expressed their deep concern with this change in policy, that is the lift of the self-stay, including Senator Feinstein, who quickly wrote a letter to Secretary Salazar, where she expressed her deep concern about the changes to the self-stay. The abrupt change in this policy, she says, has caught many who follow this issue by surprise. And she lists out a few different concerns and then she finishes up by saying, essentially, I'm very concerned. I think this doesn't comply with the tribal consultation policy, although probably most tribes would agree that they'd prefer land to go into trust sooner than later, not wait until litigation is finished. And then she finishes by saying, I urge you to open a formal rulemaking process to resolve these outstanding issues prior to implementing this new policy. And I'm getting the signal from Professor Collins, so I will hurry it up. Just last month, just a few weeks ago, Assistant Secretary Washburn, testifying before Congress, was asked, what's the defined process of the department on allowing litigations to be settled before a determination is made on lands involved? Essentially, what was being asked is, if a lawsuit is filed to stop land from going into trust, are you going to stick with your self-stay policy, or are you going to go forward and take the land into trust? And Washburn responds by saying, Patch Act has changed our views about these things, because it would previously stayed our hand on taking land into trust, the self-stay policy, while litigation was pending, largely because once we took the land into trust, we took the view that we were immune from suit at all, the pre-Patch Act view of the Quiet Title Act. And so that we would essentially moot out that case, and so to allow the courts to hear the case, we had to stay our hand. Again, you see the preference for judicial review. And he says, and so our inclination is that the self-stay policy, if you will, is not necessary any longer in light of Patch Act, which I think is entirely logical. So just a quick comparison of the pre-Patch Act world. So tribe applies for land in trust, there's a decision, there's a Federal Register notice, and then because of that 30-day window, if you were a county or a state or a landowner and you wanted to stop that land from going into trust, you had to file a suit right away. And sometimes I believe that suits were filed right away without thoughtful deliberation, simply knowing that, hey, there's a 30-day window out there. We don't know if we object to this or not. We're going to file a lawsuit. And then, of course, under that self-stay policy, the land would not go into trust. And I hate to admit, I'm working on litigation now in its sixth year, directly tied to this, where two counties, or a county and a county organization has filed suit simply to block the land from going into trust. So after Patch Act, that changes. So application for land into trust, department decision, Federal Register notice, and then there's at least two different realities. One is, let's say a county files a suit right away. Let's say it's taking longer than anyone wants for that suit to be filed. Department, now under its new policy, can still acquire that title in trust. And then the suit has to go forward, of course, anyway, but at least that's one potential advantage, is the land goes into trust even while there's litigation over it. The other possible reality is that there's no suit, land goes into trust, the tribe develops the property, builds whatever, hotel, golf course, casino, whatever it is, or doesn't do anything with it, or invests in it, and then there's a suit. That's a problem, because if there's a lawsuit, there's a possibility that the land goes out of trust back into fee. Well, the use may become illegal. If it's an Indian gaming facility, can't be on fee lands unless it's within a reservation. But there are lots of other reasons you wouldn't want that land to go out of trust, primarily tax reasons. You know, if the land, generally speaking, if the land is in fee, it's going to be taxable. So that can be a huge problem. So a few lessons from Patchik. The standing holding of the case obviously creates a much broader universe of plaintiffs for land in trust. But some potential advantages. There's no need for immediate resolution of pending litigation as long as the department continues to be willing to acquire title and trust while that litigation goes on. Now, I think the department is going to take a case-by-case view of this. I think they may still hold up and not acquire lands in trust where they expect a lot of controversy and several lawsuits. So it's going to be specific. I think it's going to limit some of these quick action suits or nuisance suits, those suits that were brought merely to prevent land from going into trust because people didn't think they had any more time than 30 days. Now, the common wisdom is that people will have up to 6 years, the APA statute of limitations. It could result in quicker acquisitions of land into trust, but suits may be permitted for a much longer period of time. And a lot of the work I do is economic development and financing in Indian country. This creates a lot of uncertainty. So if land goes into trust and someone invests $100 million into it, and there's a potential that the land could go out of trust and that person could lose their investment, that's a problem. So people are not going to invest unless they're awfully certain that even if litigation is brought, it's not going to be meritorious. A few additional lessons, with respect to tribal-state relations. Perhaps this relieves some pressure on counties and other litigants to bring these quick action suits. Perhaps it's an opportunity for others to realize that the sky will not fall if lands are brought into trust for Indian tribes. Tribes are generally good stewards and good neighbors. And as tribal leaders, planners, advocates, lawyers, let's be thoughtful about where we're asking for lands in trust. Obviously, on reservation is going to be less controversial and usually easier than off reservation. Let's make sure that the use to which the tribe wants to put the land fits with the surrounding area. One thing the Supreme Court made very clear, at least in the oral argument, Kagan and Scalia in particular, they said very, very clearly that both 465, which is the IRA, and 151, those are land use statutes, land use regulations. Now, we really never thought of them as such, but since Patchak, I think we must. So I think cooperation between tribes and local governments, states, is probably well advised. MOUs, land use plans, increased cooperation between tribes and others, not to tie the hands of tribes about where they want to take lands into trust, where they want to develop, but employing a more cooperative model to try and prevent lawsuits from being brought so that the land will go into trust and the investment will stay. So that's all I have. Thank you very much.
Well, good afternoon. I figure if you're
still here, you're probably related to one of us, or you're one of the organizers of the conference, or you just haven't realized you're in Boulder. It's a beautiful day, and happy hour probably did start long ago. My name is Ellen Roberts. I'm the state senator down in southwest Colorado, and I hadn't thought about it until Monty did his map up there, but that's pretty much what my Senate district is. I cover 8 counties. I have Pagosa Springs on over to Cortez area, Toyac, south of Cortez. I go from Durango north up to Olathe, which is just north of Montrose. So I have that beautiful territory. It also is a difficult territory to cover. As Professor Collins mentioned, state legislators, we don't have a lot of resources. We're not like the federal congressional folks. We get paid $30,000 a year, which is not nothing, but that's what we make. It comes out to probably about $2.50 an hour when you figure that we're 24/7, and we don't have staff except during the legislative session. We have typically a college student or a recent graduate for 20 hours a week. So we're pretty lean, but I am willing to do it as long as my people do send me there, but also because I appreciate what the state of Colorado gave me in terms of being a student here. I'm so old that you can't even find my picture in the hallway out here. I was a little unsettled by that. I'm so old, I haven't, this is the first time I've been in this building, so that was pretty exciting to come in and see what you all have. I'm so old that Professor Collins was 15 when he was teaching me, and Professor Wilkinson was probably around that same age at the time, but I am incredibly fortunate to have gotten a law degree in Colorado. I could only have done that because it's the University of Colorado and in-state tuition. I moved here in 1981. I was a park ranger up at Rocky Mountain National Park. Did not have a large bank account to enable me to go to law school. DU was out of the question because of the expense. And I have forever been grateful to the state of Colorado and CU for my law degree. That said, I did not like law school. I left after the first year because I thought I was not used to getting C's. I thought there was something wrong. I must be in the wrong line of business to think I was going to be a lawyer. So I took some time off. I took a year off, and I went and worked for a little law firm up in Granby, Colorado, and discovered that I really love law. And I will say that the nice, calm, cool presentations I've heard today and the PowerPoints with all the points, I gave up that world of nice, calm, cool to go into politics. So this is so refreshing, and in fact, if you all want to go to happy hour, it's okay with me, because I'll just keep standing here talking. You're getting me out of Health and Human Services right now, which is going to go on till probably 8 o'clock tonight, as people fight over a single-payer system versus the federal health bill, and I get to be here, so it's all good. I do have the privilege of having 2 Indian reservations in my district, my Senate district. And that has been a real pleasure for me. When I was here at CU, I think it was after my second year, I went down and was a law clerk in Chinle, Arizona for Navajo Legal Services, DNA. And that was, and I took Indian law here. I worked on, I don't know what edition of the Indian law casebook it was, but it was so long ago, it was probably one of the very first. But to be in Chinle's in the center, as you probably know, of the Navajo reservation, but it was very instructive to me about how we can live in a country and we can have sovereign nations here that really do exist today and want to exist in that way. And so on the Navajo, with the Navajo Nation, I was made very aware on a daily basis of what it means to protect that sovereignty. And then again, moved down to Durango in 1989, and so I've had the privilege of being close to the Southern Ute and Ute Mountain Ute reservations, and I did work for the Southern Ute and Ute Mountain Ute Indian Housing Authorities for about a dozen years, I think, combined. And so I was in Toyac a lot, and also in Ignacio, and in tribal court as well. So I would say that those experiences have helped me as a legislator, as a state legislator, in a state where many of the legislators have no clue that we have Native Americans in our state. As Ernest said, there's a very large concentration in Denver. And I think a couple years ago we had a resolution and had some conversation about how many tribes are living, folks who are tribal members from many tribes across this country live right here in Colorado. And then we have 2 reservations in our state. But because I get to hog them in my district and have them there, many legislators have no idea. And that makes for a very interesting dynamic at the Capitol. I spent 4 years in the House, and I had House District 59, which has since been redrawn, but I had the Southern Utes Reservation in House District 59, and because I had worked for the Ute Mountain Ute, I felt like they were mine too. So, and I also felt like with my experience in Indian law and tribal sovereignty issues, I felt particularly responsible, even if Ute Mountain Ute wasn't technically in my district in the House, that I needed to really be pretty aware of some of the Native American issues that are raised in today's world. I do want to acknowledge that Ernest House Jr., because I also think of his dad as well, but Ernest has been a force, and it was mentioned earlier. The continuity, he's so young, I think he started working up there at the Capitol when he was 5, but Ernest has actually been this continuity that doesn't exist in politics, and had a brief stint outside of the CCIA, but I'm so glad he's back because he is a quiet force up there. He's, I think, watching everything going on, but he also knows when to plug in and when to make sure that we don't lose track of the Native Americans that are in the state of Colorado. So I want you to know that he's a real force, and I'm so proud that he is from Ute Mountain Ute, because I just really feel like he brings a perspective, very knowledgeable, that again, I deal with so many people on a daily basis who don't come to Southwest Colorado. They have no idea, and I think in some ways we like that. We don't really want everybody moving down to Southwest Colorado, but at the same time, when you try and represent the world that we live in, and being in a rural, remote region of the Four Corners, we've got legislators that 88% of Colorado's population lives between Fort Collins and Pueblo. And I'll say that again, because 88% of the legislators, so that means 88 out of 100, live between Fort Collins and Pueblo. And I have nothing against people who live on the Front Range. It's wonderful. But what that means is a lot of those folks have no idea what the other 12 in both the House and Senate, no idea of the world we live in. Again, having gone to Chinle and gotten to immerse in that community just for a while, I would say that it's very difficult unless you live in those worlds, including my own. It's hard to relate when you talk about long distances to get to services, when you talk about the need for broadband, some of the things that people on the Front Range take so much for granted. And I think it relates to the reservations as well, that there are some folks even down in my area who don't go on the reservations just because it's not their normal path. So I think doing this here, I really commend CCIA and CU for having that dialogue, and I was taking notes about the directions we might be going in as in state and tribal relations, never, as Ernest said, never foregoing the importance of tribal sovereignty. But what we are seeing today is the federal government is letting go of things it doesn't want to do or can't afford to do. they're forgetting to let go of the requirements that they pass on to the states. And I think the important thing is, as it relates to tribes, is there's been some promises made about the kinds of that relationship that will exist, and we have to make sure that they uphold that. And I say that, I went through my little pile of what have we done in the 7 years since I've been up there. There's been 7 bills that I've been prime sponsor either in the House or the Senate that relate to Native American issues, or particularly Ute issues. And some years it's a resolution, which is more ceremonial and doesn't really have any impact. Sometimes we actually are changing laws that impact Ute Mountain and Southern Ute, and that would be like CCIA, as mentioned. Ernest used to be referred to as the executive secretary. Now he's executive director. Maybe just the change of a word, and yet what it really does is it gives more of the respect that he deserves in that role, which is not to take away anything from being a secretary, but he is directing much more than taking notes for people, and representing again the Ute tribes there. So we got into some controversial issues, believe it or not, in the last couple years. I think the one that I wanted to raise was in my district in Durango. We have Fort Lewis College. Do you all know Fort Lewis College, more or less? Yeah. So we have the Native American tuition waiver, which is a promise that was made by the state of Colorado when it received the lands from the federal government for Fort Lewis, and the commitment to provide the education for Native Americans. And as we went through particularly these difficult budget years, there was a lot of concern because it wasn't restricted to Ute students, it's Native American students. And it was tuition free. And as we have higher education costs go higher and higher, Fort Lewis became more in the radar of our joint budget committee, saying there's too much money being spent basically backfilling for these students. And so in a well-meaning but ill-advised effort to cut back on that, there was a very serious outcry from Indian country, and it was very appropriate. I tried very hard to tell the House sponsor that it was not a good idea to run that bill, and she was like, well, I don't think it'll really be a big deal. And I go, no, it's going to be a big deal. And it was a big deal, and it should have been a big deal for again, the history piece, that when we make a promise, when we make an agreement, we should be held accountable to that. And so we are trying, as the state of Colorado, to work with the federal government, because it is a much broader range of tribes that are represented, trying to figure out if there's a way for the federal government to help with some of that cost. But in any event, for now, the state of Colorado is clearly on the hook and committed to providing that. Fort Lewis, I am very proud of that college. It is a very good school, and I think it provides, because of the number of Native American students that we have there, our whole community is enriched by it. So we have a large number of Navajo students. I think that is the largest group that is at Fort Lewis, but again, I think that's incredibly important, and another strong presence of Native Americans in Colorado. I also wanted to just say, and I'm trying to briefly look through what hasn't been addressed already, but the other ways we overlap tribal and state, as was mentioned, was the Air Quality Commission. We have Animus La Plata, which I think, and I wished I could be here this morning, not only because it would help my CLE count, but I would have really liked to have heard the conversation. But Animus La Plata is has a long history in our region with many different angles to it, but it is at last, some version of it is complete, and I think that's important, and it's important to the future of the tribes in our area. I think where we overlap, in addition to some of these things like air quality or animus la plata, would be some of the looking forward things. And again, it's what I appreciate about what Ernest said today. One of the things about the resolutions that we've had at the state capitol in the past that I struggled with was a focus backward. I felt like a lot of legislators, again, were really, you cannot ignore the past or the tragedies and atrocities that occurred in the past, but Native Americans are also ready to go forward. And I think the Southern Utes and the Ute Mountain Utes are a real force in our area. And I felt like some of our resolutions try to capture people in a time 100, 150 years ago, and failing to recognize the strength of the tribes due to many of the people who are here and have ensured that we will legally have those rights for the tribes. But they are strong. There is a future that is as dynamic as anybody in the United States can have. And again, some of our resolutions looked a little too far back, and I felt encapsulated the future of the Native American people in that slice of time. And I say that we have, the Southern Ute Tribe has done some amazing things, as well as the Ute Mountain Tribe. And one of those things I can point to concretely is down in Durango, we have what's called Mercy Regional Medical Center, which is a huge medical campus that is helping to take care of many people in our area that never would have happened if the Southern Ute Tribe hadn't been willing to collaborate with the local community in Durango to see that we could preserve our hospital. I was on that hospital board during the time period where it looked like we might have to shut our hospital. We literally had leaky ceilings in our surgery rooms with buckets to collect water, and we had surgeons who said, we're not sticking around if this is, I'm talking the year 2000, 2002. So they were like, there's other places we can go, and the Southern Ute Tribe stepped up and said, we can figure this out. We can figure out a collaborative arrangement, mutually beneficial. We needed to improve access to dialysis treatment. So that was one program that really got added and beefed up. But we all benefit from the fact that the Southern Ute Tribe had that collaboration, and we now was at the time $76 million medical campus that Mercy and the Southern Utes were able to put together. So I think, again, it's that kind of forward thinking, and at the same time recognizing Southern Ute has the tribal school and many other things that are very much about protecting the heritage and culture. Ute Mountain Ute has a lot of, I know I was over there with Lieutenant Governor O'Brien in the spring. I can't remember what time of year it was, but the traditional dances over there, and I think the culture is incredibly important to preserve and have the young people speaking the languages, at the same time encouraging them to go forward, because they've been given the tools to really, like I say, move forward as all young people should be doing. I am encouraged. This past, it was a month ago when we did the CCIA bill and had the bill signing, and we always have great representation from the two tribes come up to the Capitol each year, and I think that's incredibly important for people to see. But this year was the first year I had legislators come up to me and they'd say, I'd like to come down and see. I'd like to come down because we had a bill that was on the Colorado Commission on Indian Affairs. They said, well, we'd like to know more. And if they'll drive 6.5 or 7 hours to come down to our corner, I love it, because they always seem to think it's shorter if you come from our corner up to Denver than vice versa. And so it'll be a beautiful drive or flight, whatever they choose to do. But I think it's very important that, again, that they see the two reservations, see the people and the governments that are on there, because if they we have very few lawyers, and I may be the only lawyer there that has studied Indian law. So the concept of nation to nation, tribal to nation, I think state government, oftentimes it feels like with tribes, we are, I was going to say low on the totem pole, that might not be the right phrase to use, but state government is low on the totem pole, although I would like Monty to know that you do have the Southern Ute and Ute Mountain flags flying outside the Capitol. So, and that was, again, part of the work of CCIA. So we have that tension. And again, I don't want to get rid of that tension that exists between tribes and states. I think that's an appropriate tension that states understand we're not on the same wavelength, we're not on the same level as the federal government. And that is just how it is. But a lot of state legislators don't necessarily grasp that. And again, I think it's the engagement on the issues, it's having a presence at the Capitol, and hopefully it's by coming down to the reservations. The word reservation, I think, is another one of those things that's sort of locked into a time from the past. I don't really think of them as reservations so much as communities. And I would like my fellow legislators to get a sense of that. And I think you can't do that so much when you're sitting at the Capitol as when you go into the community and see all the resources that are there. With that, I'd like to pretty much stop because, one, you might be ready for that happy hour or you might have questions for us. But I would say that, again, I very much appreciate CU and what CU did for me personally in the law degree. Despite not entirely loving law school, it was an incredible experience to be able to practice law for 20-something years and then parlay it into this little phase of my life for whatever time period that is, and then to have the safety net of my law degree to go back to whenever politics is done with me or vice versa. So if you're still a law student, I say stay at it. It is very rewarding. You just might have to know that when you look in the rearview mirror, as opposed to during that time. And again, I appreciate this opportunity to really shine a light on the people that we have in our state, the Native Americans and the Utes. So thank you.
Well, so Senator Roberts, you were at Chinley. How about that? So she has warmed us up for happy hour, which will begin at 6 o'clock at the Boulderado Hotel at the corner bar upstairs. You're all invited to join that. There will be snacks. But for now, since it's not 6 o'clock, we do have a couple of minutes for questions if you want. Yes, ma'am. Oh, the mic, yes. Where's that? Oh, there it is. Huh.
I have a question for, first of all, Senator, I want to commend you for your work with the two sister tribes, the Southern Ute and Ute Mountain. That's very good. I know we have our senator too in the state of Utah, but I wish we can have more closer working relationship with him. But I commend you for going out to meet with the two tribes. That's very good. And I believe that's a very good example of a person in the state, a congressional office to meet with, you met with your constituents. That's good. And take their interests and their concerns and take it to the state capitol. That's very good. Okay, I want to maybe clarify. I know you talked about that Pat Check Act, and just wanted to say, I believe the Narragansett tribe is a tribe that did initiate that to purchase that land and put it into trust. I believe that's where all that started, if I can recall. the Narragansett tribe. They're from back east. I believe they are asking now for the tribes to support them, to get a legislative fix done on that. And I hope that will come about soon. I know we're in support of the Narragansett and other tribes that want to have that done. Now, under this land into trust, now this is for Ernest House and the governor, how do you say his name?
Hickenlooper, correct.
Hickenlooper. I have to think, how do you say it? And Joe Garcia on our land that we're talking about, the Aboriginal land of the White River Utes in Dinosaur, in that area. Now that's not the same as what the Narragansett tribe and them are asking for. Ours is Aboriginal land, which is a difference. It's a land where the White River Utes roam. But I understand the governor and the lieutenant governor and the governor are not in support of that. But I think they have to understand where that request is coming from. It's coming from the Ute tribe, especially from the White River Band of Utes. And hope you can take that message to the governor, lieutenant governor. I don't see him here. And let them understand that we are sincere and we hope to go forward, and it may involve some land exchange. That doesn't go through land exchange with BLM. We're in process of working on that. But we're fighters, like the history of the Utes. We never give up. You can't give up on something like this, because we're looking at this casino in the state of Utah. They prohibit casinos in the state of Utah. We can't build a casino because of the constitutional requirements for the state of Utah, which is wrong. We are sovereign. But they have, it seems like the state of Utah is telling us what we can't do, telling us the sovereignty, questioning the sovereignty of the tribe, saying you can't build a casino on your reservation. But I see a lot of tribes are going forward with their casino development. Some are very successful. They're bringing in, generating revenues for their people by providing employment and some other benefits, which is good. We see it, but we are in the back there watching. And I know the Southern Ute Mountain, you guys have a casino. We don't. So only revenues we rely on is oil and gas. So that's the reason why we're asking for build a casino on our Aboriginal land. And I don't see any reason why the federal government or the state should deny us. We gave up a lot. Money and all of that is not going to ever pay for the lives of my people when they were removed from the areas, White River Utes, Mccoy Utes, the miles they traveled by foot, wagon. Some of them died along the way. Then they had to cross Green River. Then they were put on, it was a fort they built in Ouray, and that's when they brought out the buffalo soldiers to watch them. Some got sick there too. Same way with the Uinta Band Utes. They were forced out of Salt Lake Valley, Heber Valley, and some died along the way too. So we have given a lot, the tribes have given up a lot. Lives, land, valuable land. Then when we ask for things like this so we can prosper, grow, be successful, then they deny us. Then they don't give us enough money, federal budget, which under the treaties. They said they will take care of us because of the lands and stuff that we ceded, gave up, and they took from us. We lost a lot too when the Homestead Act happened. They took the best land on the Uinta Reservation in 1902 to 1905. Then they gave allotments out. The rest they gave to non-Indians. They took the best land, the grazing land, agricultural land. What do we get? Land that wasn't very, wasn't like that they gave to the non-Indians. And that's what we call the checkerboarded areas. And that's where we have problems. We have problems with jurisdiction. So, folks, I just want you to know, we'd like for your support. I know you got a lot of lawyers here. It's smart. They're the ones that fight for whomever you represent, which is good. We're appreciative of our lawyers that defend the tribe. Of course, you know, we have to direct them. They don't do it on their own. As tribal leaders, we have to let them know. And so they've done a very good job for us, but we still got a lot to go, a lot to do. And we're fighting for our water too, that's another thing. We've got the Uinta and Ouray irrigation projects, which have been there for years. And we're finding out through documentation, through surveys, through research, through investigation, there's been water theft going on. There's been water theft. So we've lost some water that way. See some of the rivers and all that. There's a loss of water. So we're trying to fix all of that, what's been taken from us. So I hope you understand that, and we're fighting for what's rightfully ours. I just wanted to make that comment. Thank you.